Thanks, Jillian. As Jillian mentioned, I think there's a lot of misconceptions as to exactly what Section 37 is. So I'd like to start by telling you what Section 37 is not. Section 37 is not a property tax. As you know, every property in a municipality is assessed, and it is basically now market value assessed, and then there's a mill rate that's applied, and that results in the property taxes that all owners are required to pay. So Section 37 is not that. Similarly, Section 37 is not a development charge, which I'll explain in greater detail. That's a specific term under the Development Charges Act. And then finally, Section 37 is not a payment or cash in lieu of parkland that is provided for under Section 42, and I'll explain that. Development charges are in fact a very detailed regime. Under the Development Charges Act, a municipality is entitled to make a charge for any growth-related costs. That is, the principle is that new development should pay for itself, and existing taxpayers should not shoulder the burden of paying for new development. So under the Development Charges Act, which came into effect in the mid-'80s, every 5 years the municipality is required to do a detailed study of all of its growth-related costs, and then it publishes the study, and then there's statutory public meetings, and there's an ability to appeal if someone doesn't agree with the allocation or the amounts, etc. Then there's an appeal to the Ontario Municipal Board, which is the planning appeal court for the province. There are 17 items that are specifically encompassed in the development charge, and this development charge must be paid by a property owner developer in order to get a building permit for every unit that the developer builds. And the current rate, the ones that are important, I'd point out, are I think the apartment unit, 2-bedroom or larger, and apartment unit, 1-bedroom and bachelor. And you'll see that in each case, every unit, every condo unit that you see being constructed here, depending upon its size, a development charge has to be paid for every single one of those units. And the intention is that they cover the 17 items that are set out in the development charge schedule bylaw. Under Section 42 of the Planning Act, it says that in any development, the developer, the landowner, must provide 5% of the land if it's a residential development, or 2% of the land if it's for any other uses. But in lieu of that, the municipality, rather than accepting small pieces of land on every development, they can accept cash in lieu of that. And under the Planning Act, there's what's known as the alternative or enhanced requirement, whereby rather than 5% for residential or 2% for other uses, for higher density, the municipality is entitled to charge a rate of 0.4 hectares for each 300 dwelling units proposed. And in a lot of sites, if you actually applied that figure, you would wipe out the development site. That is, you would have no development left. So as a compromise as such, the city has determined that if the site is less than 1 hectare, they will cap the amount at 10%. If it's 1 to 5 hectares, 15%. And if the site is greater than 5 hectares, then 20%. Those funds must be paid prior to a building permit being issued, and it's based upon evaluation of the property with its surrounding rights in place, but the valuation is as of the day before building permit is issued. And as a result of the rising land values, the amounts that are now charged, particularly where the basic amount is usually the 10% rate, can be pretty significant. And I'll come back later in the question and answer to talk about where those funds go and how they might be accessed by the community. What Section 37 does say, and I'll quote exactly from the statute, it says, "The council of a local municipality in a bylaw passed under Section 34, and Section 34 is the general zoning bylaw provision, may authorize increases in the height and density of development otherwise permitted by the bylaw, this is the zoning bylaw, that will be permitted in return for the provision of such facilities, services, or matters as are set out in the bylaw. You'll note that most people routinely refer to it as community benefits or public benefits or whatever. The actual wording of the Act refers to facilities, services, or matters, which is fairly broad, but it doesn't say anything about community benefits or public benefits. In my view, the purpose of Section 37 is the means of securing for a development and for the future, that is, making a binding agreement whereby in return for, in exchange for additional height or density above the base amount, that these facilities, services, or matters are provided. In my view, the Section 37 is the vertical equivalent of the horizontal subdivision agreement. I did some research into the legislative debate in 1982-83 before it came into effect, and it's quite clear that the intention of the government of the day was to give to urban municipalities the power, similar powers to what suburban municipalities or areas that were dealing with greenfield development, subdivisions, and therefore they needed to give a power to municipalities and to be able to do that, because municipalities are only have the powers that are given to them by the province pursuant to various legislation. And like subdivision agreements and Section 37 agreements are registered on title and binding on successors, which sounds logical and reasonable, I think. Why is it then that any time Section 37 is mentioned, people seem to think immediately of this man? Now, I can tell from the reaction in the audience, and I gave this speech at U of T Law School in January, and Julian was there, and I thought everybody knows who that is. Well, for those of you who may be too young to know, that is Monty Hall, who was the Canadian-born host of a famous American game show called Let's Make a Deal. And so that's why when I think of Let's Make a Deal, I tend to think of Monty Hall. I guess other people who haven't had that connection may not realize that. But in any event, there are similar negotiations leading to a deal as with a subdivision agreement. But why Section 37, in my view, is held in such disrepute stands from what the Ontario Municipal Board has called the lack of a, quote, real and demonstrable connection between the secured benefits and the planning approvals achieved. There have been a series of Ontario Municipal Board decisions over the years which reaffirm the principle that it's up to the municipality to demonstrate the connection, that is, some of the cases call it the nexus, between the proposal and the benefits secured. In my view, if a development project constitutes good planning in and of itself, then no benefits should be required. The purpose of Section 37 is to bring that project, it's just below the bar of good planning, but with the provision of certain facilities, services, or matters, it will then become good planning as a result of providing those things, and those are secured by the agreement. Now, how has Section 37 been used? We obtained from the city a book which is available to you through Peter Langdon, who happens to be here this evening. Peter might be considered to be Mr. Section 37 at the city because he's been involved on the city side for many, many years. But in this book, and this was one of the principles that was requested following the decisions of the Ontario Municipal Board in the early 2000s, there was a desire for transparency in terms of, well, how is this money actually being used? What is it going for? What are the uses, etc.? You can now obtain through the city, and it's been available for a while now, but you can now get a copy of this book. It is 116 pages, and it has everything broken down on a ward-by-ward basis. I must confess I didn't count the 464 projects. I looked at it and eyeballed it and said it looked like about four applications per page. But the amount, I think, is somewhere between 450 and 500. But there are certain wards where Section 37 is used more often than in others. In Ward 20, Councillor Vaughan's ward, according to this book, it has been used 54 times. In Ward 27, Councillor Kristen Wong-Tam's ward, it's been used 65 times over this time period, and the projects in Ward 28, Pam McConnell's ward, is 39 times. Some of the examples that I just picked at random from the book of good community benefits achieved are a new community centre near Burnhamthorpe Road and Highway 427. And just to understand, community centres may be one of the things listed in a development charge bylaw. The problem is, if a new development occurs sooner than was planned, in many cases there's a desire to accelerate the construction of the community centre, and Section 37 funds have been used to facilitate the construction of a community centre prior to the time it was initially planned. The Witchwood Car Barns, I'm sure most people in the room know of that wonderful facility and its artscape component that was significantly funded by Section 37. In Ward 22, there were significant improvements made to school playing fields to make them available for public use. In Ward 27, a great amount of Section 37 funds went into the development of Young Dundas Square, and in Ward 25 in Scarborough, the Warden Woods Community Centre was financed, and a significant component was financed as a result of Section 37. However, people tend to recall the examples of benefits that may be questionable. For instance, the famous dog drinking fountain. This was a project at 1430 Yonge Street where it was appealed to the board, and in a surprising decision, the board upheld that $70,000 dedicated to a dog drinking fountain was an appropriate use. Now, people say to me, well, how do things like this work in other jurisdictions? Well, the one that we're often compared to is the city of Vancouver. The fundamental difference I would submit to Vancouver is twofold. Number one, in Vancouver, councillors are elected at large, and there are no ward councillors. Now, there is a drawback to that, and I've heard it said, because there's no councillor for the downtown east side in Vancouver, that has created its own problems. But as it relates to Section 37, the benefit to Vancouver, so the first one is there are no ward councillors, and number two, and this is very, very important, that the equivalent to Section 37 benefits is negotiated by city staff with no involvement of city councillors. Now, given the history of Toronto and the significance and importance of development, I don't think that would ever come about in Toronto, but it's interesting when one compares the Vancouver experience to the Toronto one. And how does it work in Toronto? Well, the reality is that how it works varies from ward to ward. In some wards, the planning department takes a leading role. In other wards, and this has come to me directly from planning staff members, city planners, planning department's only role is to obtain from real estate services information in terms of the economic uplift that achieved by a rezoning, that is, what the value of the additional density that is achieved. And then that's provided to the councillor. So the councillor has that. That's not publicly available. If you ask the councillor, no, he or she keeps that to themselves. And then the councillor themselves, from a practical point of view, makes the determination as to where the funds go, and no other councillor will interfere with that decision. And some people will say, how can that possibly be? And I see someone in the audience smiling, and I won't point him out, but this person and I had the experience where, and it's dealing with a former city councillor, but it was a situation where there was an application being made for 3 additional floors in existing approved apartment structure. Went through the Committee of Adjustment, and there's an equivalent section known as Section 45, subsection 9 of the Planning Act, which says that on the Committee of Adjustment, the committee can impose any reasonable conditions, and usually that's translated into something equivalent to Section 37. Well, it so happened, just through a number of various circumstances, I happened to know the president of the local residents association, and immediately across from this project, there was a park that had been neglected for years by the city and was really in needing of upgrading. And so the president of the residents group and myself, representing the developer, thought, this is great. This money, which had been agreed upon, I think it was $250,000, this money should be used in this parkland, and it's perfect because it meets what I think is the intent of Section 37, that is to provide for something that results from additional density. You have the improvement of a park just across the street. Sound perfect to me. I contacted the councillor and said, Councillor so-and-so, I have an idea as to where that money should be used. And in fact, I've consulted with the residents group, and they agreed, here is where we think it should be used. The councillor paused and said to me, Patrick, I don't understand why you're even speaking to me about this. There is only one person who decides where this money goes, and that is me. I thought, oh, excuse me, Your Emperor. I'm so sorry that I should, come before you with this. And sure enough, council made sure that it did not go to where the developer and the residents wanted it to go, but this councillor had an agenda for another park, 3 blocks away. So unfortunately, that's the real world, as we say, the real world of city politics. And I'll close on this point, and I may sound like a broken record to some of you who have heard this before. The fundamental problem with the use of Section 37 and some other issues is the governance issue. You have a council composed of 44 ward councillors and 1 mayor. Each councillor, de facto, is the king or queen of their own ward. The unwritten rule around council is you stay out of my ward and I stay out of yours. No councillor will intervene in any other councillor's ward. We have elected these people who, like this councillor, is the emperor, and he or she decides where things should go, and that's a prime example is Section 37. I've been trying to, the City of Toronto has it within its power under the City of Toronto Act to amend its governance. It has the power by council resolution to change its governance. What I recommended repeatedly for many, many years, it seems now, is if you don't want to reduce the size of City Council, make it so that there is 1 councillor for each of the 22 wards. The 22 wards, in fact, coincide with the federal and provincial riding boundaries, and we're simply split in half to create the 44. So you get 1 councillor for each 22 wards, so that you have both a city councillor, a member of parliament, a member of provincial parliament to cover that area. But then the remaining 22 councillors be divided among the 4 service districts, Etobicoke York, North York, Scarborough, and Toronto East York. Those are the community councils that exist today. And those 22, depending upon population, obviously it's not an even number, there's 6 in one and 5 in the other, etc. But they run at large across the district, and they become district councillors. In this way, you'll have some oversight to where Section 37 funds go, and like the Vancouver experience, you'll have people who are not beholden to a narrow geographical area, and therefore not the kings or queens of their own ward. Those are my comment. I'd be pleased to answer questions later.